In this module, we're going to take a look at patent law. We'll probably spend the least amount of time on this area of intellectual property, and it is probably the least relevant to strategic communicators. Copyright and trademark will be more significant to you as a strategic communicator, but a basic understanding of this third prong of the intellectual property family does have some value. Patent protection has served for many decades as an important element in the technological development of the nation. Without patent law, it's doubtful that this society would have enjoyed the fruits of geniuses like Thomas Edison, Alexander Graham Bell, and the Wright brothers. The Constitution has given Congress the right to promote the sciences and the useful arts by protecting the rights of inventors. Inventors give up their secrets, basically, publishing them for all to see. In exchange, they get a 20-year government-sanctioned monopoly. There are three different kinds of patent protections. One protects inventions that have utility, such as a machine or a process. A typewriter can be patented. Patent law also protects designs, the appearance of an article of manufacture, the design of a piece of furniture or tire tread or belt buckle. A variety of patents also protect plants. Patent rights do not exist until the government issues a patent, hence the famous term patent pending, which means the patent has been applied for and is pending. Patents are granted by governmental authorities such as the United States Patent and Trademark Office. They're territorial in nature, enforceable only in the country that granted them. In the United States and most other nations, the scope and content of the claims is determined through an examination process conducted by a technically trained patent examiner. Like a contract, the wording of the claims of a patent are determined through a negotiation process involving the applicant, the patent examiner, and typically patent counsel. A patent is granted in reliance upon the representations of the applicant and can be rendered unenforceable if those representations are later proven to have been false or fraudulently made. It's important to recognize that a patent provides only a right to exclude others from practicing an invention. It does not confer an affirmative right on the patent holder to actually make, sell, use, or import the invention claimed in the patent. The patentee's ability to practice the patented invention may be restricted by the patents of others. Title 35 of the United States Code contains the statutory provisions affecting the grant of a U.S. patent. The U.S. patent system arose in response to the inequities of the English practice of granting royal monopolies. Under that system, patents were granted to known commodities such as fish or salt as rewards for service to the crown. Thus, the United States Constitution and the ensuing patent statutes provide specific criteria that limit what can be patented and who can receive a patent. In order to be patentable, an invention must be useful, novel, and non-obvious. The requirement for utility establishes the threshold attribute that must be present in an idea before it can be considered for a patent. The patent statutes provide two independent tests for determining whether an idea possesses utility. The first requires that the idea must be capable of being described as either a process, a machine, a manufacture or composition of matter, or an improvement of such classes of ideas. Inventions that fall outside of these limits, such as mathematical expressions or natural laws, are not patentable. So the requirements of 35 U.S.C. Section 101 have been used to preclude the granting of patents on methods of doing business and raw data. One increasingly important exception exists to this preclusion. Since computers are machines, methods of doing business that employ a computer, for example, a method of tracking and selling stock using a computer, or computer systems that permit a user to display or manipulate specialized data, may cross the gateway of 35 U.S.C. Section 101 and define patentable subject matter. This section further limits the availability of patent protection to only those classes of inventions that are useful. So inventions that lack any use and inventions that cannot be used or that are per se inoperable are not patentable. The patent statutes also require the invention to be novel, so that the granting of the patent does not deprive the public of any right that it possessed prior to the patent's grant. The attribute of novelty is defined by a series of 7 complex definitions. To satisfy the statute, an invention must separately satisfy the requirements of each of these definitions. Section 102 defines novelty both with respect to the date of invention and to the date of filing the patent application to protect the invention. Under U.S. law, invention requires 2 steps. First, the mental step of conception, and second, the physical act of reducing the conception to practice. The act of conception is achieved when the inventor has such a definite understanding of the invention that he or she is able to describe it in a manner that is sufficiently detailed to permit others to carry it out. The act of reduction to practice involves either the actual practice of the invention or the act of filing a patent application that is sufficiently detailed to permit others to carry it out. The patent laws also prevent the patenting of inventions that are obvious in light of the prior art. The code provides that even if an invention is novel, it may nevertheless be unpatentable if the differences between the subject matter sought to be patented and the prior art are such that the subject matter as a whole would, at the time the invention was made, would have been obvious to a person having ordinary skill in the art to which the invention pertains. The analysis is conducted in 3 steps. The first one determines the scope and the content of the prior art. One next determines the level of skill of the hypothetical person of ordinary skill, and then one determines whether the differences between the subject matter sought to be patented and the prior art would have been obvious to such a person. In the United States, you have 12 months from the time the invention was first sold within which to file either a provisional patent application or a non-provisional patent application. If you wait longer than 12 months, then you'll have forever forfeited the right to obtain a patent in the U.S. Still, in the new first-to-file era for U.S. patent law, you should never sell your invention or offer your invention for sale without having first filed a patent application. Public use of an invention can create the same problems as a sale or offer for sale. If you use an invention publicly, you have 12 months from the first public use to apply for a patent. If you miss this 12-month window, you will not be able to obtain a patent on that which you used publicly. Of course, if you want foreign rights, you need to apply first before you use the invention publicly because in many countries there is no grace period of any kind. Generally, the term of a new patent is 20 years from the date on which the application for the patent was filed in the U.S., or, in special cases, from the date an earlier related application was filed, subject to the payment of maintenance fees. Under certain circumstances, patent term extensions or adjustments may be available. Occasionally, 2 or more applications are filed by different inventors claiming substantially the same patentable invention. The patent can only be granted to one of them, and a proceeding known as an interference is instituted by the U.S. Patent and Trademark Office to determine who is the first inventor and entitled to the patent. About 1% of the applications filed become involved in an interference proceeding. These may also be instituted between an application and a patent already issued, provided that the patent has not been issued or the application published for more than 1 year prior to the filing of the conflicting application, and providing also that the conflicting application is not barred from being patentable for some other reason. Each party to such a proceeding must submit evidence of facts proving when the invention was made. In view of the necessity of providing the various facts and circumstances concerning the making of the invention during an interference, inventors must be able to produce evidence to do this. If no evidence is submitted, a party is restricted to the date of filing the application as his or her earliest date. The priority question is determined by a board of 3 administrative patent judges on the evidence submitted. From the decision of the Board of Patent Appeals and Interferences, the losing party may appeal to the Court of Appeals for the Federal Circuit or file a civil action against the winning party in the appropriate U.S. District Court. Infringement of a patent consists of the unauthorized making, using, offering for sale, or selling any patent and invention within the U.S. or U.S. territories, or importing into the U.S. of any patent and invention during the term of the patent. If a patent is infringed, the patentee may sue for relief in the appropriate federal court. The patentee may ask the court for an injunction to prevent the continuation of the infringement, and may also ask the court for an award of damages because of the infringement. In such an infringement suit, the defendant may raise the question of the validity of the patent, which is then decided by the court. The defendant may also aver that what is being done does not constitute infringement. Infringement is determined primarily by the language of the claims of the patent, and if what the defendant is making does not fall within the language of any of the claims of the patent, there is no literal infringement. Since the rights granted by a U.S. patent extend only throughout the territory of the United States and have no effect in a foreign country, an inventor who wishes to patent protection in other countries must apply for a patent in each of the other countries or in regional patent offices. Almost every country has its own patent law, and a person desiring a patent in a particular country must make an application for patent in that country. The laws of many countries differ in various respects from the patent law of the United States. In most foreign countries, publication of the invention before the date of application will bar the right to a patent. In most foreign countries, maintenance fees are required. Most foreign countries require that the patent and invention must be manufactured in that country after a certain period, usually 3 years. If there's no manufacturer within this period, the patent may be void in some countries, although in most countries the patent may be subject to the grant of compulsory licenses to any person who may apply for a license. The Patent Cooperation Treaty, or PCT, assists applicants in seeking patent protection internationally for their inventions. It helps patent offices with their patent granting decisions, and it facilitates public access to a wealth of technical information relating to those inventions. By filing one international patent application under the PCT, applicants can simultaneously seek protection for an invention in a large number of countries. The PCT procedures include filing. You file an international application with a national or regional patent office or the WIPO, complying with the PCT formality requirements in one language, and you pay one set of fees. You have to do an international search. An international searching authority identifies the published patent documents and technical literature which may have an influence on whether your invention is patentable, and establishes a written opinion on your invention's potential patentability. International publication. As soon as possible after the expiration of 18 months from the earliest filing date, the content of your international application is disclosed to the world. An optional supplementary international search, at your request, will identify published documents which may not have been found by the first search, who carried out the main search because of the diversity of prior art in different languages and different technical fields. Another option is an international preliminary examination. One of the international searching authorities, at your request, carries out an additional patentability analysis, usually on an amended version of your application. At the national phase, after the end of the PCT procedure, usually at 30 months from the earliest filing date of your initial application, you start to pursue the grant of your patents directly before the national or regional patent offices of the countries in which you want to obtain them.